Welcome to the City of St. Pete Beach Code Enforcement Special Magistrate hearing for September 9th, 2024. My name is Erica Augello, and I am the appointed Special Magistrate to hear today's cases. I am a practicing attorney licensed by the Florida Bar and am board certified in city, county, and local government law. I have been appointed to this position in accordance with the authority set forth in Chapter 162 Florida Statutes and the City of St. Pete Beach Code of Ordinances. I am not an employee of the City of St. Pete Beach and do not represent the city here today, and I do not confer with the city's code enforcement officers outside of the hearing process about your cases. It is my role to fairly and objectively review the matters presented. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order on which they appear on the agenda unless otherwise agreed. Every effort will be made to hear all persons having relevant evidence, arguments, or comment related to the specific case that is being heard. If you wish to speak today, it is necessary that you be sworn in, which I will do momentarily. All testimony given will be done so under oath. In all cases, since the city has the burden of proof, the city will present its case first. The respondent will then be given an opportunity to refute the city's allegations. Formal rules of evidence do not apply to this proceeding. However, I will make every effort to ensure that fundamental fairness and due process is afforded to all parties. After hearing all relevant evidence, I will issue an order. The order will be reduced to writing and all parties will be provided with a copy, so please ensure that we have your current address or email address. Additionally, you are advised that I do not have the authority to grant you a variance, permit, or special exception of any kind. My role is solely to determine whether a city code has been violated and, under some circumstances, to provide a reasonable time to correct the violation by whatever means are available to you. Please be advised that you may be subject to a fine and a lien may be recorded on your property if the violation is not corrected by the compliance deadline, if one is provided. If you wish to present any evidence today, please sign in at the podium before you speak, and it will be necessary that you swear or affirm to tell the truth. Therefore, at this time, I will swear in any witnesses. Anyone wishing to speak today, please stand and raise your right hand to be sworn in. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? So sworn. Are there any changes to the agenda this morning?
Morning, Special Magistrate. There is a change to the agenda. Case number 2024-0475, 5501 Gulf Boulevard is continued to the November 4th hearing. And my name is Pete Dewar on behalf of the City of St. Pete Beach Code Enforcement.
This is agenda item 4A, or 4, what is it, 4D? Okay. And this is the respondent represented by Mr. Denhart?
Yes.
Okay. All right, any other changes to the agenda?
We made an error in an address, 369. Should be 396 instead of 369. Case number 2C, 2024-0172. The address is 369 41st Avenue, St. Pete Beach. Thank you.
Okay.
And Madam Magistrate, if I may, on the first one, just for the record, this continuance to November 11th, we could just include language that it doesn't preclude the city from adding to the evidence November 4th. There's no need to be redundant and say you can't short-term rent because that's what our code says.
Sure.
Thank you.
Okay, and prior to proceeding, I did receive 3 orders that were returned undeliverable to my office based on the last hearing, so I will leave these with the city as they are public record.
Thank you.
Okay, moving on to case number 2A, or agenda item 2A rather, case number 2024011, City of St. Pete Beach versus Colonnades Apartment Condo Association.
Thank you. Good morning, Special Magistrate Louis Cruz representing the City of St. Pete Beach Code Enforcement. This is a status hearing on a 30-day extension to secure an after-the-fact permit for the fence. This was not done to its entirety. City will be asking for $250 per day starting August 7th, 2024, until property is compliant, plus $325 in administrative costs.
Okay, so the permit had not been applied for as of yet.
It has been applied for, but it has not been secured.
Okay, and I don't have a copy of my order in my agenda materials. Did it say that it had to be, did the order say that the permit had to be obtained?
Secured.
Okay.
Yes, ma'am.
Okay, and you said $250 a day is what you're requesting from 8/7 until compliance?
Yes, ma'am.
Okay, is anyone here on behalf of the respondent?
Yes.
Okay, could you please state your name and affiliation with the respondent for the record?
Greg Garrell, I'm the HOA president.
Okay, and you have the authority to speak and represent the Colonnades Apartment Condo Association?
Yes, I do.
Okay, and what would you like to say?
We applied for the after-the-fact permit I think on August 4th. It was denied. I think we are in the process of trying to secure a new survey because the survey didn't locate the fence according to what they needed for the permit office. So we're trying to secure a new survey so we can resubmit the thing, so we can get to the next step of getting this completed.
Okay, and did you contact the code enforcement department during that period of time once you got the denial of the permit and request additional time to comply?
I did not. I did send Louis Cruz an email stating some of the facts that we had looked up in the case, and our contractor said that get the survey and then he'll resubmit. It does have a target date of 9/19 on the denial. I don't know what that means.
Yeah, neither do I.
Yeah, so, I mean, what I'm trying to do is secure a new survey company because the past survey company that did the first one, I think it was in April, didn't complete it, and now they're not interested in completing it for whatever reason.
Okay,
So I'm trying to secure a new survey company
okay.
through our current contractor.
And if I recall, nobody from Colonnades, there was a resident here at the initial administrative hearing, but nobody from the HOA was present.
We had a management change and a president change and a board member change right in the middle of all this. Our last president left for health reasons. I then got nominated to do it. When I got this handed to me at the end of May, I called Mr. Cruz. We discussed it on the phone. He said I had until June 28th to submit for a permit. That first contractor that they had hired prior to me then skipped out, didn't do nothing, basically took the money from the HOA, and he's gone. So then by the 8th, I was not here because I was told that entire time that he was going to get this permit done. It didn't get done. I missed the 8th. I live out of state. And then you guys gave us a 30-day extension. I hired a new contractor. We submitted our past survey with the new contractor on August 4th. You guys denied it, and here we are today. So I'm currently looking for a new survey company to get this done.
Okay,
And I think the issue is just locating the fence on the current survey, or if the new company has to make a whole new survey to locate the fence. But this fence, from what I can tell, has been there for maybe 20 years, and all we did was power wash it. And then it got cited from him back in March, and here we are today.
okay. All right, thank you very much. And you said you signed in on the?
Yes, I did.
Okay, perfect. All right. Any questions for the respondent from the city?
I just have one question, Madam Magistrate. So what took so long from July 8th to August 4th to apply for the permit? If you can just explain that for the record.
We hired a new contractor. He had to get all his documents together and apply for it. He applied for it on August 4th. It was supposed to be applied for by the 7th. And then it was denied on the 7th, I believe.
Okay.
So after the 8th, we were notified, I think, by mail or whatever it was, 2 or 3 days. And then we then secured a new contractor. We had to get him paid prior to him doing it. So then it had to go to the management and all that. And then by the time we got him paid, then he applied for it as within a week.
Thank you.
Okay, anything else? Okay, anything further from the city?
No, ma'am.
Okay. All right, I have already found that the property was in violation. The property did not come into compliance with my prior administrative order. I am going to assess a $50 a day fine starting on August 7th, running until the property is in compliance. And you can certainly get with the city on that and see whatever you can do after that. But until the property, because of the time frame that it took, understanding that there were challenges, that's why I'm not issuing the $250 a day. But there was somebody from your community that showed up at the initial hearing. You had the ability to stay in contact with the city and ask for additional time. None of that was done, so I am going to assess the $50 a day fine plus the $325 in administrative costs, and I will get you an order to that effect. Okay, moving on to case number 2024-0287, City of St. Pete Beach versus Thomas M. Cudahy Revocable Trust and Thomas M. Cudahy as trustee.
Thank you, Madam Special Magistrate. This is a status hearing on a 30-day extension to secure an after-the-fact permit for the structure. Property is not compliant. The city will be asking for $250 per day starting August 7th, 2024 until compliant, plus $325 in administrative costs.
Okay, and again, I don't have a copy of the order. Can you just remind me what this case was?
This was for like the tiki hut structure that was built in the back of the property.
Right, okay, I do recall that. Okay, and so has the permit been applied for, do you know?
Not to my knowledge. I don't know if he ever applied for it, and if he did, it just didn't get secured all the way to its entirety.
Okay, all right, thank you very much. Is the respondent here or anyone here on behalf of the respondent? Good morning. Please state your name for the record.
My name is Tom Cudahy.
Mr. Cudahy, what's going on?
I applied for the permit 2 months ago, over 2 months ago. I got a receipt from Joanne Boland. Thank you for doing business with the City of St. Pete Beach, and I thought we were done.
Okay, so you're saying that you've applied for and secured the permit on this?
I paid for the permit and never got any response.
No, there was
except
no
for the receipt
response
from
received.
Joanne Boland.
Okay, did you contact the city to see where in the process they were? Because this was something that was already built, correct? And so you were just trying to get an after-the-fact permit for it?
Correct.
Okay. And what day, can you recall what day you applied for the permit?
It was over 2 months ago, 2.5 months.
Okay,
I was here 2 months ago.
Yeah.
I'm a patient up at Moffett. I had to go through a procedure up there, and so you gave me the extra month.
right.
And the permit was applied for prior to that. Actually paid for it, got the receipt.
Okay, and you never heard anything back from the city in that
Figured
period
we were
of time?
done.
Okay. All right, any questions for the respondent?
No.
Okay. On behalf of the city, do you guys know, I mean, I understand usually sometimes you have your building official or someone from your planning department here. Do you know where they are in the permitting process on this?
No, not to my recollection. I just remember looking, and then on our software program, I can see if something's been opened and that they've obtained the permit. When I went to check it last week, I did not see that there was a permit actually obtained, so I'm not 100% sure on the exact details. I should have brought that, but I do not know all the way through.
Okay. On this one, because I have testimony that says it was applied for and that the city has been dragging its feet for the last 2.5 months, and I don't have anything from the city saying why that might be or any other information, and there's no one here that I can ask on behalf of the city, I'm going to grant an extension on securing the permit until the next hearing, which will be on October 14th. So we will come back again on October 14th and see what the status of the permit is. Mr. Cudahy, I would suggest trying to contact the city to see where your permit is and if there's anything that they need from you, because it sounds like there's just a lack of communication.
Okay, so you want me to come back on October 14th?
If we need to come back on October 14th, we'll come back, but I will give you until October 14th to get that permit secured, and then we'll check in on that date to see what's going on with the city, if you've gotten your permit or not.
I'll go right now.
Okay,
Thanks.
thank you very much. Okay, moving on to agenda item 2C, case number 2024-0172, City of St. Pete Beach versus NXT Acquisitions Corp.
Morning, Madam Magistrate. Steve Rivera on behalf of City of St. Pete Beach Code Enforcement. It's a status hearing for the 30-day extension to secure permits for work being done on the property. I have here It's an online application only. They have not secured the permits. This was submitted on 8/7. On 8/8, we did send them what needed to be done to complete the permit. So it says building application uploaded to the permit. The whole scope of work needs to be on the application. Application needs to be signed and notarized by the owner of the property and contractor. Needs a FEMA packet, NOC, and subcontractor sign-on. There's been no communication
Since then?
since then.
Okay. Okay, is anyone here on behalf of the respondent, NXT Acquisitions Corp.? Have you heard anything from the property owner on this?
I heard from one of the property managers. She said that they were trying to get another contractor to fill out the permit. We kind of went around in circles. They were answering their own questions. It looked like there was so many people in the email that one person would ask, and somebody from the same corporation was answering the email. But according to this, they had 30 days to have it done. 8/7, they waited to the last minute to even get an online application in. But there's been no movement there. I haven't heard since the last hearing. I think I've heard from them twice, and that's it.
Okay. Okay, just checking again, anyone here on behalf of NXT Acquisitions Corporation? Okay, and what is the city requesting?
Based on the extension, we're looking for $250 a day from 8/7 until compliant, plus the $325 for administrative costs.
Okay, I am going to grant the city $250 a day from 8/7 until the property comes into compliance, as well as $325 in administrative costs. And I'll get you an order to that effect.
Thank you.
All right, moving on to agenda item 2D, case number 2024038, City of St. Pete Beach versus 3511 Gulf Boulevard LLC.
Good morning. Again, Stephen Rivera on behalf of the City of St. Pete Beach Code Enforcement. This is a status hearing on the 28-day extension to cut the grass, weeds, and remove the palm fronds and silt fence. I did speak with the property owner. He did get the property cut in time. I do have some photos. The overhead, please. So this is the lot here, showing that the property's in compliance now. I did talk to him, forgot to mention to him again about the silt fence, so we're willing on working with him. I do have his phone number now. Other than that, the property looks great. The complainant actually called to say thank you. So at this time, just looking for administrative costs.
And what amount of the administrative costs?
$325, I'm sorry.
Okay. Is anyone here on behalf of the property owner, 3511 Gulf Boulevard? Just for the record, I did receive a garbled voicemail. I have no idea what was said on the voicemail. My paralegal told me the gentleman was calling about 3511 Gulf Boulevard. I did not speak with him, but just for purposes of the record.
He was out of town. He had hired a contractor. Contractor came once, cut the grass, never showed up again. He actually got back to me after the hearing. Went out there the next day, did an assessment, hired another contractor, and then came into the city to explain what was going
happened?
on. I went out, did a follow-up inspection, missed the silt fence during the inspection, so I'm not going to hold that to him. But I do have his number. It's just a matter of him picking up the
Perfect.
silt fence, yeah.
Okay, great. Well, then, I will find that the property is now coming into compliance, and I'm only going to assess $325 in administrative costs.
Thank you.
All right, moving on to 2E, case number 202400157, City of St. Pete Beach versus 1008 Airport Road, LLC.
Thank you, Special Magistrate Louis Cruz, representing the City of St. Pete Beach Code Enforcement. This is a status hearing on a 28-day extension to bring the property into compliance. This was where they had the dumpsters out that were exposed that needed to have a dumpster enclosure. That was not fulfilled. They put in for a permit, but I don't think it met any of the marks that needed. So the city will be asking for $250 per day, starting 9/9/24 until compliant, plus $325 in administrative costs.
Okay. Is anyone here on behalf of the property owner, 1008 Airport Road, LLC? If you could please come up, state your name and affiliation with the respondent for the record.
Yeah, I'm Jonathan Finch, the general manager over at Resort Rentals.
And do you have the ability to speak on behalf or represent 1008 Airport Road LLC?
Yeah, I have a power of attorney.
Perfect.
Do I need to?
If you just put on the overhead, that's fine. Perfect. Thank you very much.
And then, to be honest, a lot of this stuff is me, 100%, and my lack of understanding and never have gone through this before. And so I'm just going to take full ownership of it. So we did originally, when we got the first citation, acted immediately, and I called multiple contractors. I need to get approval for that kind of stuff, but I got multiple contractors, had someone come out. They said, I can do this, but they looked it up and said, no, this needs to be a masonry enclosure. And then, so I got a different contractor. That person came out and said, and I'm used to contractors, and everything takes a long time. It was during my busy season. The contractor I ended up going with, I put her even, I think, on the email with Mr. Cruz here, and she said, yep, I'm in contact with the city. I'll get this done. And what else do I need to do? My fault, I should have went to him and not to the contractor, I guess. First time doing it, and then fast forward, because I know how long it takes. I get something else saying, hey, it didn't comply. And I go, wait, hold on. So I call her up. I go, hey, I'm going through my busy season. What's going on? And she said, through the email, I'm decided that we're too busy to do any of this. So it went from, I'm going to do it. Don't worry about it. I'll talk to the city, everything on your behalf, and do all that. Bill you for the hours to, I'm past due, and nothing ever did it. So I, that day, got another contractor. She just had to schedule multiple different appointments to have her walk the lot. Her name's Sonia with Kitchen and Bath. She then said she was going to speak to the city, all that stuff. Now we're basically here, which I thought the permit was done as of the 28th. But I again, not knowing everything I need to do, I didn't realize that, so what I have here, I guess, doesn't mean anything. So I thought the permit was actually submitted and done on the 28th of last month.
Okay.
So if it's not, then figure out what else I got to do, and I'll do that. So, but I am in contact with Sonia. She's awesome, but apparently she did miss communication that was sent to her email saying a certain document that was needed. She filled that out and turned that in on, I believe, the 26th or 27th. And then I got this email from her stating, told me to bring this in and saying that the permit, everything's good.
Okay, can you put that on the overhead so I can see what you're looking
I
at?
thought it was good, but again, if it's not, I'll do whatever it takes, so.
Okay.
Can we
to
go
the-
overhead, please?
No,
Sorry.
you're good.
Can we zoom in a little bit?
My eyesight is not what it used to be.
Can we zoom in a little bit, please?
Apparently
You
not.
want, I just.
All right.
Yeah.
No, it's the other way.
Oh, yeah.
Okay, so it basically just says this is the online application, everything's been submitted, but it's not yet been through reviewer.
And some of the holdup was the original, as you can see, like the description, the scope of work is the dumpsters. But again, it's also on the left-hand side where we need to do a variance for the laundry, which isn't on there, but it's a separate one, but kind of falling under the same umbrella. So they've been, I guess they submitted for a variance. I don't know the status of that. But on the other side of the building, we gotta do that as well. But we're butted up against, right up against a house that has a 4-foot fence. So I guess we need the variance for 6-foot. You can probably
Fence.
speak to that. So, but again, yeah, I apologize for my ignorance on a lot of this stuff because I don't know the codes. I don't know a lot of this stuff. So I am learning, but this just happened to be my trust in a contractor that didn't pan out. And then I had to start all over.
Okay, any questions from the city of the respondent?
Just one. So you already
to your knowledge, you've already applied, or they've already applied for a variance for the fence, for
yes.
the fence height? Okay.
Because we had to do another site map.
Site plan.
Site plan, there we go. I had to do another site plan, so we had to schedule them to come out, draw up the blueprints, and then submit it. But I was told this stuff takes a long time sometimes.
Understood.
So that was my fault for thinking the long time. I was just good.
So putting the enclosure aside, which is a permitted item, you picked up the paint cans, the debris, equipment stored outside with public view, all of that's been cleaned up?
Yeah, absolutely. Actually, two different. We picked up that stuff pretty soon after, within the time frame. But recently, we went even more above and beyond. We actually did trimming of the tree. We cleaned everything out over there. So I think we were to standards though very soon after the original citation. But
I do have a quick question. Is the enclosure permit for the masonry dumpster enclosure contingent on receiving the variance?
that it was made, I think it is. Brandon, who came out and walked with me, that was made. That I think it is.
Okay.
But
So
I don't think anything was in writing that it had to be.
That they had to be.
But I was made to think that, not maybe intentionally.
But it,
So I don't.
Mr.
I
Cruz,
could be
can you
wrong
speak
on
to
that.
that
I
at
thought
all?
it had to be done at the same time. Said, hey, you're doing this, so you should probably do this too.
okay, Mr. Cruz, can you speak to that?
So for the dumpster enclosure, he doesn't need the variance. The variance is for a different situation that he's having with the, he has like bins sitting out there on the side of the road that need to be enclosed as well. That's a whole separate issue that they're trying to do at the same time. So that's why he's kind of getting them bundled together now, when the dumpster enclosure should have been, you know, kind of the number one thing to get done, because that's what was cited.
Sure, but if he submits a permit to the city, is the city going to know that the dumpster enclosure takes precedent over a permit application for a building permit that otherwise includes a site plan review or anything of that nature? Or are they going to run them concurrently?
That's what I wouldn't know. It's kind of a permitting question for some.
Well, that's why I'm asking you with the city to see if that's,
Yeah, I can let it be known to the permitting department, of course, but because of the contractor trying to put them together, you know, it's reviewed together, so that's what I wouldn't know.
sure, okay.
And I will say one thing, and again, this is nothing, not to be argumentative at all. The reason why they're put together is because every time I spoke to someone about it, it was, you need to do this also. So
Right.
I felt like that was a fair assumption that I needed to do both. But
Sure.
I would have, if it was just the dumpster, that's way easier job than
rest of it.
doing the left side of the building with the variance, which again, me not knowing, I should have known that, I guess.
That's right. It just sounds like they were running them concurrently. Okay. Based on the testimony here today, I am going to allow for an additional 30-day extension until the October 14th hearing since the permit has been applied for, to let it go through the process, and then we will reconvene on October 14th to see if there's been a good faith effort to secure that permit. I'm not going to issue any fines or award any costs here today, but we'll come back on the 14th and see what the status of the property is. And I will get you guys, just make sure we have your contact information, because I am going to send an order to that effect, so just sign in if you haven't already.
Yes.
May I ask one question?
Yes.
Are you opposed to bifurcating the permits if need be to get the dumpster enclosure squared away while you work through the variance?
I'm assuming that's separate the two. I didn't even know
Yes.
what that word is
Sorry.
until today, so that's good. Yeah, that's
Okay.
fine. I have no issue with
All right, thank you.
whatsoever.
Thank you.
Okay. All right.
And one final question, because I know Mr. Cruz talked about it before, but I heard kind of two different things. In the meantime, we're supposed to do the enclosure, but I was just a question on the, every contractor we brought out, numerous contractors we brought out said, why didn't you just put a fence right, from here to here, covering that? Why does it need and so all the contractors were telling me, man, this doesn't need the enclosure. And when they looked up the code, it was kind of iffy on whether or not if there was a fence there, you shouldn't have needed one. So that's why.
a question that you should bring up with the building department, with the city of St. Pete Beach. They're going to be able to interpret their code and let you know exactly what needs to be done. But this is something that's come before me before, and depending upon where it is, it needs to be a masonry enclosure for a dumpster.
Oh, thank you so much.
Thank you.
Okay, moving
And Special Magistrate, real quick,
Yes.
you said November 14th?
October 14th.
October 14th, okay, thank you.
Yeah.
Yes.
Did you say the permit needs to be secured?
We will come back on October 14th to do a status check to see where you are in the process. But if, to Mr. McConnell's point, if you can go to the city and separate those two permits so that you can actually secure the masonry dumpster one, I would do that so that you can come into compliance. The code case will go away.
So I should leave out here, go over there.
Next door.
Madam Clerk, October 14th is, the city's open, right? I know it's Columbus Day.
It's Columbus Day, but that's the day that it said that was the next
Yes.
hearing.
We are, okay. I can never remember.
I believe it's Indigenous
Indigenous
Peoples' Day.
People Day, yes, thank you for the clarity.
Yeah, Matthew.
My whole childhood just
I know.
gone. Okay, moving on to 2F, case number 20240265, City of St. Pete Beach versus Barbara McMahon, the estate of.
Thank you, Special Magistrate. This is a status hearing on a 28-day extension to bring the property into compliance. This was the property that had like overgrown grass in the right-of-way on the property, outside storage. I had a junk vehicle which was removed. I went by this morning. It is still out of compliance. The city will be asking for $250 per day, starting 9/9/24, until the property is compliant, plus $325 in admin costs.
Okay. Have you had a chance to speak with the property owner's daughter? I know she was the personal representative of the estate.
Yes, she hadn't reached out. Most of the time I was talking to her husband, who was doing most of the
Okay.
conversations that I've had with pertaining to the property. She has not reached out. He has not reached out since the last Special Magistrate hearing.
Okay, so nothing from either of them. Okay. All right, is anyone here on behalf of the Barbara McMahon estate? Okay, seeing no one. Did you have something,
Just
Mr.
one
Cole?
question for Mr. Cruz. Did you go out to the property at all?
Yes, this morning.
And it's still,
Yeah, it's still out of compliance, has overgrown grass, has still piles of dead vegetative debris stacked up against the house, and still some trash and stuff scattered in the backyard.
what about the vehicle that was on the property?
The vehicle was removed, the fence was fixed, it was all rusted, he did get that fixed. It looks like they may have mowed at some point, but again, just not taking care of the property. It looks like it may have overgrown again as
Okay.
well.
Do you have any photographs of that by chance?
Yes. This is the property at 579th Avenue.
Okay, so they've made some efforts, but they're still
Yes.
not in compliance?
Yes, ma'am.
And they have not contacted you to tell you that the property is otherwise in compliance or any?
No, usually he's pretty
information.
responsive. The husband would reach out, and he hasn't even
Okay.
contacted me at all since.
Okay. I will find that the property is still not in compliance with the city's code or the magistrate's order. I am going to assess a $50 a day fine from 9/9 until the property comes into compliance and award the $325 in administrative costs. Okay, moving on to agenda item 2H, case number 20240150, City of St. Pete Beach versus Russell Zimmerman. Mr. Cruz?
I think we skipped one.
Did we?
Yes. G.
Oh, we did. Moving on to 2G, case number 20240281, City of St. Pete Beach versus Richard Allen Long Revocable Trust and Richard Allen Long as trustee.
Thank you, Special Magistrate. This is Louis Cruz representing the City of St. Pete Beach Code Enforcement. This is a status hearing on a 28-day extension to bring the property into compliance. The property was to submit for a permit for the sign that was there for like breakfast, lunch, bar sign that they have there. Either remove it to come into compliance or obtain a permit. It has not been removed, nor has a permit been applied for. So the city will be asking for $250 per day, starting 9/9/2024, plus $325 for administrative costs until compliant.
Okay. Anyone here on behalf of the property owner, Richard Allen Long Revocable Trust, or Richard Allen Long as trustee? Anyone here on behalf of Richard Allen Long Revocable Trust or Richard Allen Long as trustee, 6800 Gulf Boulevard? Okay, seeing no one, I will find that the property is still not in compliance with the city's code or the magistrate's order and assess a $250 a day fine starting 9/9/2024 until the property comes into compliance, as well as $325 in administrative costs. Right,
you.
now moving on to agenda item 2H, case number 20240150, City of St. Pete Beach versus Russell Zimmerman.
Thank you, Special Magistrate. Louis Cruz representing the City of St. Pete Beach Code Enforcement. This is a status hearing on a 28-day extension to bring the property into compliance. This was the property that had like outside storage on the porch, had deteriorating wood on like the fascia boards, rusting on metal posts that it has on the porch, and an unregistered vehicle. I did do a re-inspection this morning. I have the pictures if you would like to see, but it is not in compliance. So the city will be asking for $250 per day, starting 9/9/2024 until compliant, plus $325 in administrative costs.
And have you had any communication with the property owner at all?
He has not reached out since the last time I talked to him, probably a week before the previous special magistrate. He has not reached out to me at all since.
Okay, and has there been any movement on bringing the property into compliance, or it's in the exact same state that it was previously?
At the exact same state it was at previously. The only thing was, and I'm pretty sure it was the same thing as last time, I can't remember, but he did have overgrown grass, which he has been staying on top of. There was no overgrown grass.
It was just everything else
I
on
don't
the
think there was the last time we were here for that.
Okay.
I think he got that taken care of.
Okay, anyone here on behalf of Mr. Zimmerman, or is Mr. Zimmerman here? Anyone here on behalf of Mr. Zimmerman, or is Mr. Russell Zimmerman here? Seeing no one, I will find that the property is still not in compliance with the city's code or the special magistrate's order. I will assess a $250 a day fine beginning on 9/9/2024, running until the property comes into compliance, and assess a $325 administrative costs.
Thank you.
All right, agenda item 2I, case number 20240381, City of St. Pete Beach versus Jason Gabby and Janelle Gibby.
Thank you, Madam Magistrate. Stephen Rivera on behalf of the City of St. Pete Beach. We had the PowerPoint, please. This case was continued from the last magistrate hearing. Was unable to present last time. Case number 20240381, respondent Jason and Janelle Gabay. Violation address 6 Mangrove Point. Violation description, the property is in violation of 98/123.1, permits required of the Code of Ordinance of the City of St. Pete Beach. Case summary, initial inspection, 7/3. Notice of violation dated 7/3. Notice of violation compliance date 7/18/2024. Notice of hearing dated and posted to the property 7/22/2024. The following is a true and accurate representation of what I witnessed. This is the affidavit of posting, 6 Mangrove Point. This is the unpermitted fence that was erected close to the structure. This is a picture of the fence that's now removed. Corrective action, property must obtain a permit or remove the fence near the dwelling. Property is compliant. Recommended fine, $325 for administrative cost only. And that concludes my presentation.
Okay, is there anyone here on behalf of Mr. or Mrs. Gabay?
Morning, Magistrate. My name is Charles Gertis with the law firm of Keen Reese Gertis in St. Petersburg, 1766th Street North, Suite 205. I represent the owners, Jason and Janelle Gabay, and as you've seen, the property is in compliance. This was a result of a mistake. When my clients purchased the property in August of 2023, it was an eyesore, rundown, hadn't been taken care of. There was some, if you're familiar with lattice work, boards at Lowe's or Home Depot, decrepit boards. My client believed that he could just replace those with these fence panels, fence panels. He was wrong. As soon as we found out about the violation, I reached out to Mr. Dewar. I reached out to Matthew McConnell at the city attorney's office. We had some back and forths about after the fact permits. We decided the best way to go was to remove it, just take it down. It was gone. I'd asked the magistrate to either waive the administrative fee or to reduce it in half or something. I right away started communicating with the city and the city attorney's office to try and resolve this quickly. I think we resolved it certainly to the satisfaction of the city. The fence is gone, so the violation is gone. And I just asked the magistrate to take that into consideration. Thank you.
Certainly. I do have a question for you. Understanding you're asking for a waiver of the administrative costs, the city had to go through the steps in order to bring this case before me. Is there a reason that you know of why your clients were not able to remedy the situation either by the notice of the notice in the notice of violation, or I believe this was previously continued, so by the last hearing?
It was previously continued because I requested that. I had a conflict with another hearing, so I appreciate the city doing that. Otherwise, the back and forth between myself and the city in terms of why the permit was required, what's the best thing to do, how long would it take, those kinds of things. Yes, my client, is paying my hourly fee. The city incurred some costs. I would just ask the magistrate to take into account that my client did the right thing and tried to address it right away.
Anything from the city?
Yes. Do you know when your client came into compliance? What date?
I don't know the exact date, but it was obviously prior to July 29th. The picture is dated July 29th, so it was obviously prior to that. I believe it was a few days before that. I had asked Mr. Dewar if we could dispense with the hearing altogether after the fence came down. I was told that wasn't appropriate. There still needed to be a hearing. I was hoping to get rid of the necessity for a hearing, but it was within 5 days of the July 29th picture, Council.
Okay. May I just confirm that with Mr. Rivera?
Yes.
I'd have to go back and look. We wouldn't be here if it was in compliance before the compliance date. So the notice of violation went out, we passed the compliance date. There was communication shortly after the compliance date, but by that point the property was already posted.
Yeah, I'm not sure.
Mr. Gabay had stated to me on the phone that he didn't know about it until he saw the posting on his property. And that's what was stated to me from your client.
I can't tell you today, sitting here in all candor, I cannot tell you that it was done by the 18th of July.
Right.
But I can tell you it was done prior to the 29th, obviously.
I will say, once there was communication started, there was swift movement, but we were not in compliance by the compliance date.
And the city has obviously an objection to waiving administrative fees. This was a 60-day process from start to finish. I was involved multiple times. I'm not even charging for all my time, to be honest with you. I think it's fair. If you want a reduction, then we can recalculate and charge exactly what was charged and maybe address it that way. But I think $325 is more than fair.
Well, and I'm also taking into consideration that the property wasn't in compliance by the compliance date, and under Chapter 162, the city does have the ability and the right, if it so chooses, to ask for a daily running fine from 7/18 until the property came into compliance on the 29th, and they're not doing that. So while I appreciate the request, I do find that the property is now in compliance with the city's code. But but I will find that it was not in compliance as of the date of the deadline within the notice of violation, which was properly addressed and received by your client, so I will award the $325 in administrative costs.
Thank you, Magistrate.
Thank you very much for your time.
Thank you.
Okay, we have no agenda items under 3 repeat violations. Moving on to agenda item 4A under new cases. Case number 20240429, City of St. Pete Beach versus Cast Holdings LLC. Mr. Rivera.
Thank you, Madam Magistrate. Stephen Rivera on behalf of the City of St. Pete Beach Code Enforcement. Case number 20240429, respondent is Cast Holdings LLC. Violation address is 3612 Gulf Boulevard. Violation description, the property is in violation of Section 12.2, permitted principal uses and structure of the Land Development Code of the City of St. Pete Beach. Case summary, initial inspection 7/23/2024. Notice of irreparable or irreversible violation dated 7/24/2024. Notice of hearing dated and posted to the property 7/24/2024. The following is a true and accurate representation of what I witnessed. This is the affidavit of posting at 3612 Gulf Boulevard. This is a screenshot of the Airbnb listing. So it shows the reviews here, May 2024, May 2024, April 2024. And we have June 2024, stayed about a week. May 2024, stayed about a week.
Can you go back one slide, Mr. Rivera? Just want to make sure that Iris is a new one. Thank you.
Bless you.
Thank you.
And we hear July 2024, stayed about a week. June 2024, stay with kids, number 7. June 2024, stayed about a week. Corrective action, the property can only be rented monthly. Recommended fine is $1,000 per review for 8 reviews, plus the $325 for administrative costs.
Can you
And that
Go.
concludes my presentation.
back? I didn't,
I'm sorry.
maybe my math is bad. I saw 4 reviews, not 8. So are the 3 that you initially did, those were the 3 they're allowed to have, correct?
This isn't in the Passive Grill area. They're monthly rentals only.
Okay, because my agenda packet says,
Are they not RM?
It is RM.
it's the RM 12.2, says transient occupancy less than 30 days is only permitted 3 times within a 12-month period.
Correct.
Correct.
Thank you. I was about to make the same distinction.
12.
And I do want to clarify, if we can go back from the beginning, please.
All the way to the front.
Just to the where the reviews start. Okay.
So April, May, those are all 3
Correct.
allotted and accounted for.
Correct.
So they're allowed to have those, okay.
Technically, no further until May of 2025. So
Okay.
there was actually
There's another one.
there's 3 in May. There was
How
3.
are there 3 in May? Go back again? Oh, no, go back again?
Iris is different. So you have 1 in April, you have Vicky, Zach in May, and
Right.
then Iris is in May as well. Next slide, please. So Iris is
Right, those are 2. So the first May 2024 is the first violation,
correct.
and then June,
then
so that's 2.
That's 2.
Go ahead,
Next
Mr.
slide.
Rivera.
Go back or forward?
Forward. 3, 4, 5.
And then 1, 2, so that's 5.
And can we include the Airbnb policy, because the one in the middle of the screen says stayed with kids. The city's position is because the one preceding that says
Stayed about a week. You wouldn't be able to get a 30-day.
Correct.
I agree. I accept Airbnb's review policy into evidence.
Thank you.
So then by the city's count, there are 5 that are in violation of the code, and
Correct.
that is irreparable, irreversible, asking for $1,000 for each of the 5
The
violations.
city is also requesting proof of rentals and no short-term rentals until July of 2025.
July 2025.
Which is a year from the last comment.
And the 325 in administrative costs, correct? Okay. All right, anything further from the city?
No, ma'am.
All right, anyone here on behalf of Cast Holdings LLC? If you could please come and state your name and affiliation with the respondent for the record.
John Castellano, good morning, Magistrate.
Good morning.
I apologize, but I had no knowledge of this rule. There are a lot of folks in the neighborhood that are renting weekly that I've known of, and I've basically following their action. Upon finding out of what the actual code was, I've changed all of Airbnb, I changed my website, updated everything, so I would not violate any rules or don't want to cause any problems. Obviously, I don't want to, have any issues at all, so I was unaware of it, made every corrective action I could to prevent it going forward.
Okay, any questions from the city?
You said your name was John,
Castellana.
and I'm assuming you're the manager or registered agent of the
Yes.
LLC? I don't have any questions besides, do you have any addresses or names of the people that you know in your neighborhood that are doing it?
Yes,
Do you mind providing those to the city?
I prefer not to.
Okay.
I'm sure if the city looked into it, they
It
could.
was worth a try.
It was an effort. I was going to be real surprised if he was like, yes, my neighbors are.
And my name and address is.
Right, right.
Thank you.
It's like, did you kill that guy? Yes, I did.
No, nothing further. Do you understand what we're doing here today? Is because you're allowed 3, so what we're requesting is that you can't do it for less than 30 days, for now, a year.
Yes, I understand.
And then once that year is up, then you're allowed 3 less than 30 days in a 12-month period.
Correct. I spoke to Barry, I believe.
Yes.
He said that it's actually 28 days or 29 days, depending on the month, 30 days.
February is always
Yeah.
an interesting. Okay, I just want to make sure you understand. Thank you, sir.
It was pretty specific on 30 days, which sounded a little weird.
Okay.
Thank you.
Well, very good. I do find that the property is in violation of the stated code section. I am going to assess $1,000 per each of the irreparable, irreversible violations, which of which there are 5, plus the administrative cost of the city of $325. You will receive an order to that effect, and I would consult with the city to see what you can do about that, if anything. And also make sure we have your information.
You do.
So I can send you that order. Thank you very much.
Okay, so there's a $5,300 fine?
It's $5,000 for each, so $5,000 in fines, $325 in costs. So $5,325, if my math is correct.
You can work with the city. There's a lien reduction process and other things that you can do in this situation. You can work with them offline.
Okay, moving on to agenda item 4B, case number 20240358, City of St. Pete Beach versus Babette Simone or Simon.
Good morning, Stephen Rivera again on behalf of the City of St. Pete Beach Code Enforcement. Case number 20240358, respondent's Babbitt Simon. Violation address is 305 Gulf Way. Violations description, the property is in violation of section 44.5A1, 2, B1, 2, 3, 4, 5, 6, and 7. Standards for existing beachfront lighting of the Code of Ordinance of the City of St. Pete Beach. Case summary, initial inspection 5/23/2024. Notice of violation dated 7/2/2024. Violation compliance date 7/16/2024. Notice of hearing dated and posted on the property 8/19/2024. The following are true and accurate representations of what I witnessed. This is the affidavit of posting at 305 Gulf Way. This is a picture of the property from the beach. This is the lighting violation. That light picture there is on the north side of the building. It's another light toward the back side that could be seen from the beach on the north side of the building. During a follow-up inspection, there was 3 more lights that were visible. The 2 are on the west side of the building, in the front there on the bottom, and then the one to the right, that's on the south side of the structure. Same lights in the front, and then the 2 on the side both lit during this inspection. Corrective action: property must turn off lights, shield lights, or replace the bulbs to be turtle light compliant between the dates of May 1st through October 31st. Property is compliant. Recommended fine is $325 plus administrative costs. I do have pictures of it being in compliance. So this is the property now. The light that is seen here can't be seen from the beach. At the time of my follow-up inspection, they're replenishing the dune, so I couldn't get out to where they were working at. This is actually right from where the dune starts, so I'm on the street side of the dune, out on the beach side of the dune in this photo here, but you can see it's completely dark. Another picture from the other angle. So she is in compliance now. That concludes my presentation.
Okay. Is there anyone here on behalf of the property owner, Babette Simon? Anyone here on behalf of Ms. Simon? Did you happen to speak with her at all?
So, yeah, we spoke with her, myself, Mr. Dewar. I actually spoke with her attorney. Ms. Babette isn't, she's an elderly woman.
Okay.
Sometimes has a hard time remembering things.
Sure.
So we were trying to work with her. It was after the fact that the property was posted. Had we had gotten communication prior to that, we probably could have
Avoided
been
this.
here.
Okay.
But I did speak with her attorney. He did promise me it would be done, so I actually went out on Thursday. Thursday night was my last day before the weekend, and it was in compliance like he said it would be, so.
Okay. Do we know if they just shut off the lights or if they've replaced the
So,
bulbs?
the lights weren't on, and when I did a day inspection, I did see a couple of the lights were like the bug-style turtle-compliant lights. I think the other ones they just turned off. Some of the lights are motion censored. They weren't on at the time of inspection. But again, that's part of the corrective action. They said they can just turn them off.
Right.
So at this time, I'm going to say it's in
They're compliant. Okay. Okay. I am going to find that the property is in compliance with the city's code as of the date of the hearing, and I'm not going to assess any fines, but I will assess the $325 in administrative costs.
Thank you.
Moving on to agenda item 4C, case number 20240430, City of St. Pete Beach versus Christopher and Brianna Smith.
Thank you, Special Magistrate. Louis Cruz representing the City of St. Pete Beach Code Enforcement. This is Code Enforcement case number 2024-0430. The respondent is Christopher Smith and Brianna S. Smith. Violation address is 7700 Boca Ciega Drive. Violation description: the property is in violation of Section 32.5, Prohibited Uses and Structures of the Land Development Code of the City of St. Pete Beach. Case summary: the initial inspection, 7/24/2024. Notice of irreparable or irreversible violation dated 7/24/2024. Notices of hearing dated and posted on the property 7/24/2024. These are a true and accurate representation of what I have witnessed. This is the affidavit of posting at 7700 Boca Ciega Drive on July 24th, 2024. This is the Airbnb advertisement of the property, hosted by Brianna, which I'm assuming is the property owner. Just a little synopsis of the property owner. Just some shots of how I did my research and found the property. And as you can see here, there are a lot of different stays. And I can go back if you would like. Just want to go through some of the photos. Due to there being so many, I kind of have at the end a total of the short-term rentals. In 2023, in June, there were 2 stays. July, there were 5 stays. August, there was 4 stays. September, 3 stays. October, 5 stays. November, 2 stays. In 2024, there was 1 short-term rental stay in June.
Can you show me the June one again and tell me how you determined that was a short-term stay? Stayed a few nights?
Yes.
Okay.
Yes,
I
ma'am.
missed that when you were flipping through them.
If you would like me to go back further, I can.
No.
Okay.
That's not necessary.
And that was a total of 22 short-term rentals. Corrective action, property can only be rented monthly. Recommended fine is $1,000 per review for 22 reviews, totaling $22,000, plus $325 for administrative costs. And that concludes my presentation. Thank you.
Okay, and just, so for my purposes, how were you alerted to this property, or was this something that you actively found?
Actively found. Sometimes when we have, certain periods, we look through, we see what we can find on Airbnb, Vrbo, sometimes Facebook, stuff like that, because there's so many different ways you can actually rent now, so we don't have a software program for it, so we do our own research.
Okay, and in finding this property, that's when you determined that you went back as far as you could and found the other short-term rentals? It wasn't something that was already on your radar that you just waited to prosecute?
No, this was something that once I found it, I went back a whole year, so I went back as far as I could to the time that I found it, which was July 24th, so I tried to get around that ballpark, so I'm not going, where's the line of how far you go back, so we went
About
back
a year. Okay. All right, and have you had any conversations with the property owner at all?
No, the property owners have not reached out at all.
Okay, thank you very much.
Thank you.
Is there anyone here on behalf of Mr. and Mrs. Smith, Christopher or Brianna Smith? If you could please state your name and affiliation with the Smiths for the record.
Christopher Smith.
All right, Mr. Smith, and what do you have to say?
So when we bought the property, we didn't know. We were told by our agent we also live on the property, but we were told that it was commercial corridor, so we share the same zoning with a brewery, with restaurants, so we just weren't aware. However, we do occupy one of the units. The other 2 units were rented short-term, but we also, periods of time, we would do long-term stays, just whatever we could really get. And all that was really doing was helping us offset the costs of the property. Once we were alerted about this and I, looked into it more, did more due diligence on the zoning and the codes and such, I realized that we were in the wrong. So we've since rectified that. Within a week of the notice, we do have, one unit's vacant, so we are actively looking for, long-term tenant to place. The third one is currently being occupied under lease agreement, so that one's like a 6-month. So we, again, we just weren't aware. First-time home buyers, we're on a single income, so I really can't afford to pay $22,000. And I just was not aware of that. So again, we are, we do have one lease in place, one unit's vacant. Well, and also upon the notice, we also did remove those listings, from pretty much everywhere. So again, I do acknowledge that I was in the wrong there. Me and my wife were both in the wrong, but again, we don't have the money to pay the amount of the violation. So we'd ask for, leniency on just the first offense, and now knowing what the codes are, so.
Okay, any questions from the city?
No.
Okay, and Mr. Smith, you said that is this like because I only have the Airbnb advertisements, is this like a triplex or?
Yes, Your Honor, it's a triplex. Me and my wife live in the one of the units, so we live downstairs, and the other 2 we rent out. So again, it's a partial homestead too. So we're on the property. We actively manage it and stuff like that. But again, upon notice, we did rectify it as soon as possible. We weren't clear on the codes and we didn't really know about it. We just call it not being naive and just not doing the proper due diligence. But we again, we've since rectified that.
Okay. And how much were you charging for each of those stays on average?
So there were long periods of time where one of the units was one, like, we were renovating it and we just weren't getting bookings. But I believe one of the smaller units, and it's like 400 square feet, I think we were charging between, it really depended on seasonality, but it would go between like 115 to like maybe 160, 170 a night on average. Maybe the average being like 140 to 145.
Okay.
I do have one question.
Yep, go ahead.
When you say rectify the situation, was there any rentals that you had that you've canceled for future? Like any short-term rentals that you had booked that you canceled?
Yes, I believe that once we did do that, I think we might have had like one or two that we had canceled. But I think at the point in time, we were pretty much, one of the units was completely vacant. The other one was, I think it maybe had, again, one or two that we canceled immediately as soon as I got the notice on my door.
Thank you.
So.
Okay, anything further from the city at all? Okay. Okay, I am going to find that the property was in violation of the stated code section, and I'm going to tell you what for your benefit, because you've not been at all of these magistrate hearings, but it is the property owner's responsibility to find out legally what you can and cannot do with the property when you purchase it in any jurisdiction. Taking your realtor's word for it is not enough. So that's something you may want to bring up with your realtor. Based on what I'm about to say, because you do have 22 short-term rentals. The city could have gone back as far as they could have. They didn't. They did it within a year. It was very obvious. You haven't negated the fact that you have violated the city's code. Consistent with all my previous rulings, I am going to assess a $1,000 fine for each of those 22 rentals, which will amount to $22,000 plus the $325 in administrative costs. With that being said, you can get with the city. There is a fine reduction or a lien reduction process that you can go through, but to stay consistent with my rulings, based on the fact that, you talked about you were able to renovate some of those properties, that you were using it to offset the costs, and the fact that you didn't do any due diligence at that time, that is why I am giving the ruling that I am. But again, get with the city after, and there may be some ways to alleviate the cost to you.
Okay. Thank you.
And make sure I have your information so I can send you an order to that effect. Okay, we have continued case 4D. Moving on to 4E, case number 20240409, City of St. Pete Beach versus Alberto Espinosa.
Yes, thank you, Special Magistrate. Louis Cruz representing the City of St. Pete Beach Code Enforcement. This is Code Enforcement case number 2024-0409. The respondent is Alberto Espinosa. Violation address is 5960 Bahama Way North. Violation description: the property is in violation of section 6.23 Docs G and 98-65 Unsightly Conditions 1, A, and B of the Land Development Code and the Code of Ordinances of the City of St. Pete Beach. Case summary: initial inspection was 7/17/2024. Notice of violation dated 7/23/2024. Notice of violation compliance date 8/15/2024. Notices of hearing posted and dated on the property 8/23/2024. These are a true and accurate representation of what I have witnessed. This is the affidavit of posting at 5960 Bahama Way North, August 23rd, 2024. There's a dock in disrepair on the back side of the property at 5960 Bahama Way North. This is my first picture. A little bit zoomed in, the dock that was in disrepair. This was my re-inspection of the property, August 22nd. Property must remove the dock or fix the dock, in which both situations require a permit. Property is now compliant. I did go over and I spoke with the property owner this morning, so there will be no recommended fine. The city will only be asking for $325 in administrative costs. If you could put on the overhead for me, please. Property owner has removed the pieces of the dock that are in disrepair. I thought it was the whole thing, but it looks like there was some that was still structurally sound, so that would not require a permit. The property is now compliant, and that concludes my presentation. Thank you.
Okay, anyone here on behalf of Mr. Espinosa? Okay, if you could please come up, state your name and affiliation for the record.
Alberto Espinoza, owner. The only thing I'd have to say is I just got the notice a week ago. I was out of the country for the summer, and as soon as I did get word from a tenant who saw the posting, he sent me the posting plus the first page of the violation letter, so I didn't know what really had to be done. But as soon as I got it, I called Mr. Dewar and then Mr. Cruz, and I got back, and I immediately fixed it when I returned back in the country, which was this weekend.
Okay.
I just did not know about it. So.
Understood. Okay, well, I am going to find that the property is now in compliance with the stated code sections. I am not going to assess any fine, but I will assess the $325 in administrative costs.
Okay. Thank you.
Thank you for your time, Mr. Espinosa.
Moving right along.
Okay, moving on to 4F, correct? Yes. Case number 2024-0391, City of St. Pete Beach versus Diana Street Properties, LLC.
Thank you, Madam Magistrate. Stephen Rivera again on behalf of the City of St. Pete Beach Code Enforcement. Case number 2024-0391. Respondent's Dana Street Properties, LLC. Violation address is 3614 Gulf Boulevard. Violation description, the property is in violation of 4633-3, enumeration, and 9866A, B, and 20, residential and commercial property maintenance of the Code of Ordinance of the City of St. Pete Beach. Case summary, initial inspection was 7/9/2024. Notice of violation dated 7/10/2024. Notice of violation compliance date 7/25/2024. Notice of hearing dated and posted on the property 8/28/2024. The following are true and accurate representations of what I witnessed. This is the affidavit of posting, 3614 Gulf Boulevard. This is pictures of the overgrown vegetation. Corrective action, property must cut and maintain vegetation regularly. Property is compliant, recommended fine, $325 for administrative cost only. I did get I got a phone call and then I got an email over the weekend from the property owner explaining that they had sent someone out to cut it and changed contractors. This is a picture of the property now in compliance. Show you the half of the yard. They did say that they were going to have a new landscaper cut and maintain it regularly. Apparently it was only being cut once a month, according to the phone call I got. But with all the rain we've had lately,
Yeah, no kidding.
yeah. That concludes my presentation.
Okay, anyone here on behalf of Diana Street Properties, LLC? Good morning. If you could please come up, state your name and affiliation for the record.
Hi, Geeta Dasani. I am the LLC member of the Diana Street Properties, LLC.
Good morning, Ms. Sassani. I believe I've seen you before me.
Oh, yes.
Before. All right. And
I'm not an attorney.
yeah. Do you have anything else to contribute? It looks like the property is in compliance now. Do you know if it was in compliance prior to the compliance date or?
So I'm going to show you what it looked like. So when I received the citation, the second citation, the initial citation is when he's referring at 710. It was corrected. And if I can do that thing where you can see it up there.
Overhead, please. I was just
Yeah,
letting them know.
you can, and you can put your phone on the black mat. Yeah. No, the black mat right in front of you. Yep.
Right in the square.
Okay, so if you see this, I'm going to go slow so you can see the dates.
Okay.
Can we zoom in a little bit, maybe?
Please. Not you.
Well, actually, you know what I can do? I can take screenshots and then I can zoom in.
We were asking the camera operator.
Oh, there's somebody. Oh, somebody.
Yeah, no worries. It's the voice above us.
That's
The wizard.
Can you see it?
Yes,
No, but you can't see
the date.
Yeah, so.
Can you just,
You can just testify to the date.
yeah, or you just drag to the left on the
Yeah.
message.
It won't show you date, it will show you time.
Time,
Fair.
date's up top.
So if you see here, can you see the date now?
No, just tell me what date. Oh, I see it. Okay, July
July
24th.
24th.
Yeah, okay, so July 24th, 9:15, that was the from the original citation, I had asked if that was taken care of, and that's when it was taken care of, July 24th. You know what, I didn't show you, give me a second, I didn't. Okay. Can you see this date now?
You can just,
Yeah, just tell us
July
the date.
12th.
The 12th. Oh, I see it now. The 12th.
So if you look at this, I had asked my landscaper, hey, can you swing by 3614? He said, yes, ma'am. Can you make it a priority? That was, if you look at the date, and he said he would make it a priority. And then July 17th, because he had said on the 12th he would take care of it. On the 17th, I asked again, and then could you swing by? And then he said he's heading there now. That was 17th, the same day he responded. And then on the 24th, I asked if it was taken care of. And then that's when he sent me the pictures, which you saw. These are the pictures, and the date, I know you can't see, but that's July 24th. And then I'm going to go forward, and I got another citation, which was August 2nd. When the first July citation, the 29th, and when it was resolved, I had called the officer prior, before the violation expiration date. You need to give you 10 days to take care of it. It was taken care of, even though I had to, we have several properties here, and I can't. I can't come every week to check to say if grass was cut, if this was cut, and they're all long-term rentals. So the tenants usually manage that process. If they need something, they call the landscaper directly. They're not short-term rentals, so we don't get calls on them. We don't get, they're responsible. We do take care of the maintenance for this reason. So the landscaping and pool we take care of. Because I do know the city's extremely particular. But so I had called the officer, Rivera, and left a voicemail. I didn't get an answer back, and I explained that, hey, this was taken care of, Then I got another citation, which was 3 weeks later, because July 29th, as you can see, was taken care of, and then on August 10th is what the second citation was dated for. Within that 3 weeks of 21 days, we had 17 days of rain. And as you can see, in the 10 days, how much I had to chase him to make sure my lawn, did he take care of it? Because I don't know if you probably didn't read the text message, but I said I wanted to have pictures documented so I can present it to the city in the event I have to come back for this particular reason. Because it's just unnecessary. I truly feel like and within that 3 weeks, and he called me and he said, we've had excessive amount of rain. We can't, I've been trying to get the guys to go out there, but every time it rains or thunderstorms, we can't go out there.
Right.
Anyways, the second time it was taken care of, and I want to show you.
So I have a question. You did all this I saw the dates on that. The pictures were from July 24th, and on that date you said then you called the code enforcement officer and left a voicemail.
Yeah, he never called me back. So when I got the second citation, immediately I called. And he said he never went out to close the first citation. And when he went out there the second time,
it was overgrown.
It was overgrown again. And then I went out there again. So on that day, I'm like, there's no way. In that time, it overgrew. So I drove myself out there, and I want to show you pictures from that. His pictures look, for that reason, I was like, maybe he'll show pictures that look a little extremely overgrown. So I went out there and measured it, and yes, there were some weed up to 21 inches. But when I say just one weed, that was 21 inches. Everything else was probably around 10 to 12 inches. But it is taken care of. Even then, I chased my guy, and I was like, please go out there. I had his office manager sent me a text to confirm that they're now going out there twice a week. I understand that they're committing to going out there twice a week, and I want to show you. I just don't want to be out here another 3 weeks because he went out there and he saw 12 inches of grass.
Well, and my question is, if you called the code enforcement officer, then the overgrown grass that you're seeing was something that developed from July 25th to the date, whatever date you went out there. Is that what you're saying?
July 24th, what you saw when it was cut,
Right.
to August 10th.
August 10th.
This was cut, so now so this is from the office, they messaged me this, hey, this is Taylor from Bill's Landscaping, it would be $60 to cut, $120 a month. So they're charging me $100 a month to go out there once a month. Now they dropped it to, it's only $120
To go twice.
a month. Really not that big of a deal. And I said, yes, can you please email it to me, the agreement? Because I wanted to forward the email to him, but they never emailed. Again, I know there's so many people come in through here, and I'm sure you've had work on your house done. It is impossible for contractors, landscapers they do go out there and do their job, but to the extreme of managing something, because they do 5 of our properties out here. And I haven't heard a single complaint from any of my tenants that, hey, this is an issue or overgrown, or, landscapers not doing their job. They are, in the last, 6 years we've been out here, this is the only landscaper in the last year and a half that I've had is actually very good and receptive to this level. I know that it doesn't feel like I'm harassing him every other day. I'm like, did you go out there? Because I don't want to pay $375 or $250 fine per day.
Right.
But yes, so now you can see that it has been resolved, and there's proper procedures. He recommended you need to go twice a month instead of once a month. It is just a lot, but you can see, and then I asked him for more pictures. I was like, please send me pictures if you went out there, and this is what it looks like now. Oh, you can't see.
Can we see the overhead again? Thank you. Okay.
1 second. Did you see this?
Yes.
Oh, you did? Okay.
Yep. Okay, any questions from the city?
I just have one question, probably for Mr. Cruz or Mr. Rivera. What notice is she speaking on August 2nd?
There was a notice that went out, I believe in November, was a courtesy notice, was the first time.
November.
Okay, let's discuss November. That was almost a year and a half ago. Okay, sure, yeah.
So November was the first courtesy notice. This time we actually sent out, it was in August, it was an actual notice of violation. The second notice I think you're referring to is the affidavit of posting on the property.
So the only notice of violation I have in the packet is from July 10th. So are you prosecuting a July 10th violation based on a violation that you're now saying was issued in August?
No, I'm sorry. The notice of violation was in July. August, I went to close out, do a follow-up, close out the case, and that was when the property was overgrown again.
And do you recall receiving a voicemail from Ms. Dasani?
Well, I do remember talking to her last week, right after I purchased the property. And I've had several emails from her saying that she was going to have the property maintained regularly. I don't remember getting a phone call, but again, around that time frame, I was out of the office. I did explain that to the respondent. That's why I didn't get closed out. I don't remember getting a phone call on the 24th. That's the date.
July 24th.
July 24th.
July 24th.
So I remember getting a phone call on that date. And again, when I did go to close it out, it was almost a month later, and it was overgrown again.
Anything from the city?
Well, let me.
Yeah, and I'm being honest, but there's a pattern. Even if it was 2 weeks before that, she stated she was only getting the property cut once a month. It would have probably been 2 weeks before that, probably was still.
And that's fine, but you have a compliance date of July 24th, and I have credible evidence saying that, and demonstration that it was July 24th and that she called you, and you just can't recall if you received a call or not.
So,
The one on the citation.
Mr. McConnell?
yeah, I'm going to try to mediate this situation, if I may. So Florida statute, chapter 162, does allow us, because technically speaking, if she came into compliance prior to the date, we would not be here. But 162, and I can find the reference, allows for a reoccurrence, right? So if there's a reoccurrence prior to a hearing, then you can still bring them to the hearing, which is why we're here today. So, but I appreciate the evidence presented. I think the city's position is find her in violation and repeat in the future, no cost at all. No admin costs, no fines. Just close out the case. She clearly has a 2-week issue going on. I can find the citation in 162, because if that citation, if the magistrate doesn't agree with that citation, then technically we shouldn't be here at the hearing.
Yeah, I'm going to look for that. Just because it rings a bell, but.
Yeah, just. Yeah, there is. I've used it.
So it does say in chapter 162.06, subsection 2, if the violation is corrected and then recurs, or if the violation is not corrected by the time specified for correction by the code inspector, the case may be presented to the enforcement board even if the violation has been corrected prior to the board hearing, and the notice shall so state. And the notice says, can't read the notice of hearing because it is a photograph. The continuation of the violations of the city code. Okay. Okay, anything else?
Yes.
Mr. Sani?
The notice that the original notice he's speaking of, that was a year ago, over a year ago, when we demoed the home. So there were debris on the property, not significant, but yes, and we were asked to landscape it because we couldn't leave it in the condition of just like bare. Because there were no grass before when the house was on there. It was just pavers and then so we put brand new landscaping there. So we just grassed all the way through. That was over a year ago when the property, or maybe, yeah, of the previous year. November of the previous year.
Right, 2023. Okay.
22. Couldn't have been 20. We demoed it.
I wasn't here, it's 22.
But you didn't leave the
Oh, no,
note.
I sent a notice, a courtesy notice in 23, November of 23 as well.
Okay. Regardless, we're not here on
Okay,
that,
yes,
right?
It was cut before, you're right. The home was demoed before January 1st, 2024. Okay, yeah, you're right. So there was a home on the property on 23. We bought it, yeah, and then we tore it down in 2023. Yeah.
Okay. The city does have the right to bring the property back to me because of a continuing violation in the interim. However, I do believe that there's credible evidence to demonstrate that even in the interim, the respondent has made every effort to make sure that the property remains compliant with the code, as well as the fact that there is credible evidence to suggest that there has been a lot of rain and landscapers can't get out there when it's raining or if it's lightning. So I am not going to find that there is a violation of the stated code section, and I'm not going to award the $325 in administrative costs based on the credible evidence. And I will get an order out to that effect. Just, Ms. Dasani, make sure that I have your email address to send that to. I will say that to say this. Please be vigilant, because if you come back before me and there's a continuing, even if it gets remedied before the hearing, but it's continuing, I'm not going to be able to, I may not be able to make the same ruling, because then that creates a pattern.
No, I understand. I am doing the best I can.
And I can
for a
understand.
landscaper to go out there, and this is the most credible company that I've found, like people that I've found. On any of our other properties, we haven't had any issues.
Okay. And I understand. I just want to make sure that you know, because I
just don't want to be harassed.
Here again.
10 inches of grass again.
Right. Understood. Okay. Thank you very much, Ms. Dasani. Have a good day.
Thank you.
Moving on to agenda item 5, no cases complied. 6, there are no old cases. 7, lien reductions. Case number 20220487, City of St. Pete Beach versus, oh no, again, I apologize. Limbevsky?
Yes.
I'll just stick with the last name. The Limbevskys.
Madam Special Magistrate Pete Doerr on behalf of the City of St. Pete Beach Code Enforcement. This is a lien reduction request. And so you have a packet up there, yes?
I do.
And so the city is agreeable to a 90% reduction. The request is for the entire fine to be rescinded. And so the city is asking or agreeing to $8,750.50. I'm sorry, $8,750 plus the administrative cost of $446.
Okay.
May I ask you a question, Mr.?
Yes, sir.
Or Madam Magistrate? May I ask Mr. Doerr? Because the lien reduction application states that the total fine is $166.96, but it's the city's position that the total fine is actually 87500,
Yes,
plus the admin cost of 446 for a total of 87,946.
You sure you guys don't want the 160? Okay, so this, by the city's calculations, the actual lien amount, which looks like it runs $250 per day for 350 days beginning November 7th, 2022 through October 23rd, 2023, is $87,500 plus $446 in administrative costs, which differs from the applicant's math, which looks like it's $160,000.
and the city made yes, the answer to your question, Matthew, is that the amount that the respondent indicated is incorrect, based on, could we go to the overhead, please? Based on what Madam Special Magistrate just mentioned, $250 times,
Can we zoom out a little bit?
which is calculated,
Thank you.
is calculated from November 7th, 2022, as indicated on that. And the property came into compliance with the certificate of occupancy.
Do you have the first page of that order, Mr. Dewar?
N23, 2023. The first page of,
Mr. Thanos' order.
Thanos's order.
the first page is, first page, overhead. So from November 7th through, November 7th, 2022 through October 23rd, 2023 is how we got to 350 days times $250.
Can I see page, Madam Magistrate, are you still reading
Two.
page 1? May I go to page 2?
Page 2, you said?
Yeah, the order says the previous orders finding the respondents to have been in violation of the cited provisions of the city code are reaffirmed, as they were not abated by the compliance date set in either the August 8th or the November 12th orders.
And page 3 says that the respondents are directed to bring the property into full compliance with
By
property
November
maintenance
15th.
requirements.
I guess I'm just trying to understand what full compliance means. Not to put you on the spot, but
At the time, it included the
is it just maintenance or did it include a CO?
CO, both
Yeah.
the maintenance and CO, because we had to make arrangements with the respondent to have a construction plan. The city was, the property sat without a CO for several years, and so we required that the respondent get the CO included in the order and maintain the property at the same time.
Yeah, Mr. Thanos's order says only that the respondents are directed to take all action needed to have licensed contractors complete the work in accordance with permits issued by the city and in accordance with the letter from Mr. Anderson dated October 10th, 2022. I don't have that letter, so.
But Mr. Dewar, you were at this hearing,
Yes.
and is your testimony that the city's position was not only bringing it into maintenance requirements, but also receiving a certificate of occupancy for the unpermitted work? I mean,
That is correct. The property sat, as I said, without being completed, including not having a CO. And so that was part of the requirements, not
Okay.
just the maintenance.
Right, because
then
it was
just-
Chapter 98.
just
Okay.
to sum up, I think
And so,
Although there's 160, the city's position is it is willing to take 10% of 87.5, which would
Yes,
be
sir.
8,750 plus admin cost of 446.
Thank you.
okay. Is there anyone here on the behalf of the Limbevskis? Yes. Okay, if you could please come and state your name and affiliation for the record.
My name is Kosta Limbevsky. I'm the owner, co-owner with my mother and father, Damcha and Linda.
Okay, and Mr. Limbevsky, if you'll just walk me through your request for a lien reduction.
Sure. I was underneath the understanding from the special magistrate. This all started with there being the property being used with cars parked on the lot without us having a CO. We were building the house and we were within our permit time during the entire thing. We never violated that. And so we started to receive citations. We corrected those immediately. And then when we came to the special magistrate, the idea was that the city did not want the construction to be taking too long. So we had to we hired two general contractors that were licensed and an attorney at the same time. And we got everything done within 11 months of that special magistrate hearing, which I believe was within a reasonable amount of time. Any other code infraction we were completely compliant with. We responded immediately. Anytime we had a list of anything to do, we did what was necessary and worked underneath the idea of possibly being fined. But the impression that we all had was that if we completed the construction project, which again was demolishing an old home and building a new one, and we ran into a lot of problems with COVID and things as such, and my parents were dealing with the construction process and were being swindled a little bit. They're in their 70s. So I came out here, and within 11 months, the project was completely completed, and we received our certificate of occupancy, and we were only made aware that we thought it was already rescinded, because that was the agreement. A year later, after the certificate of occupancy, we get an email saying you still owe $160,000 and $250 a day because you're not compliant. In order to get the certificate of occupancy, I myself personally did, and also my attorney, checked. You have to be free of any liens, or you can't owe anything in order to get your certificate of occupancy. And we checked that date, and it was 0. So a year later, this appears, which is 2 years after this initial special magistrate order that said, yes, you're completely compliant, but we want you to rush the construction. We want you to get this done. It has taken too long. And if you do it within a reasonable time, well, we won't have to, this will be forgiven. And
Okay.
that's what I was operating the assumption under. We already had to pay 2 general contractors for what they called emergency case situation, where we had to pay them extra. We had to pay 2 different attorneys to get this done within the 11 months since the court hearing. So,
Okay. And then so understanding all that, and because I don't have the benefit of having been at either of those hearings, all I have is the benefit of Mr. Thanis's orders.
Right.
Were you or anyone representing you or your family at all of those hearings?
I was.
Okay.
Every one of them.
Okay, and so then you were aware of what needed to do in order to seek compliance with
Yes.
the last order?
Yes.
Okay. And so at this point, a certificate of occupancy has been issued, the case is closed, and now the city sent you a notification saying you have an outstanding lien amount. And so do you understand that the city's, their lien calculation is less than what you've come up with? So I hope
Well,
that.
no, this is I have the email I could show you that Mr. Dewar sent
Sure.
me. That was from the city.
I wouldn't argue that, because you have that you want to request a $160,000 fine to be reduced. Their calculation is it's only $87,000 to be reduced. And they're willing to reduce that to $8,750 plus the administrative costs.
The point of that is once we get the certificate of occupancy, they can't fine us anymore.
Correct.
The number that we were given was kind of a ridiculous amount because it included a whole year that we were beyond compliance. So
Well,
That's
and
why
so
I
that's
used
my
that
question,
number.
Mr. Dewar, what was yeah.
That's the issue, because that's probably where the 160 came from. But if you look at the worksheet, the fine stopped on October 23rd, 2023, which is the date the CO was issued.
Yeah, but the city sent me an email saying you owe us 160.
Sure. So the city's email that it got sent was likely based on a different calculation. As of today, your fine reduction I'm assuming the city made a clerical error, and the actual amount of the fines is $87,500.
Yes.
Okay.
Yeah.
Clerical error. We did not know that he obtained a CO, so the fines were running up until the date he got the email. Subsequently, we found out he got the CO, and we
A year prior.
Okay, understood. And keep in mind, too, that I'm not reading Mr. Thanos' order, but I'm pretty sure it's standard that, in order to come into compliance, you need to make the city aware. It is a little bit confusing when you make the city aware because you receive the certificate of occupancy from the city, you assume so, two different
We
departments.
had a lawyer dealing with it, too.
Yeah, I saw Mr. Dion was in there from, okay. All that being said, I understand that you would like a 0 reduction in the fines. The information I have sitting here today is that you had representation, or you had represented yourself throughout the entire process, that there was a validation in making sure that there were code violations and there was a fine assessed with that, and that the city says that the total amount of fines was $87,000. They are willing to reduce that by 90%.
Totally understand that, but where my question comes in is the code violations were dealt with immediately. In the special magistrate hearing, it turned into, we want you to get your certificate of occupancy. So if you get this done at a reasonable rate, you won't have a fine.
Sure, and I don't have any problems with that, but I have an order that says in order to comply with the violations of Chapter 98, which I believe have to do with permitting, that the way to comply with that is to, the order says hire 2 general contractors. The order does not say receive a certificate of occupancy. It just says to come into compliance. The city is the one that determines whether or not that's what is compliant. Apparently, the city has testified that the compliance would have been a receipt of a certificate of occupancy, which you have done. Yeah. So on that date, you complied, but it was after the date of compliance in the order. Understanding, again, I wasn't here. I don't know what that testimony is. I only have what I have here, which is you're asking for 0, but you're also telling me that, you received a certificate of occupancy X amount of days after the order said. So
wait, and I'm very confused. I just want to clarify.
Sure, please do. I am also, so feel free.
At the special magistrate meeting, they said this is what you need to do. You need to no longer be the general contractor yourself or anybody in your family. We said, we're not. Okay, well then hire a general contractor. We did that, and get this project done as fast as possible. All of the other things like moving a car or the grass or the infractions were dealt with the next day.
And those are not part of the order that I'm reading.
I'm not understanding what we didn't do in order to receive any fine.
So, okay. I reread page 1 because this was obviously almost 2 years ago. If you look at subparagraph 4.
Where am I looking?
The order from the special magistrate.
Yeah.
So subparagraph 4 says?
Get either.
It says the respondents were notified that they were in violation of section 98-65 and 98-66 of the Code of Ordinances by not maintaining the property in compliance with applicable standards, and were in violation of section 3.7 of the Land Development Code
for not having
a certificate of occupancy.
But we could never have had a certificate of occupancy. It was a new construction project. We demolished the house and built the house. How could we have a certificate of occupancy? The argument was that we had a car parked on the property, and that would be that we were maybe using it, and we moved the car. How could we not? I don't understand it. And then we have to get our certificate of occupancy when we're done building from the city. So all of those delays were on the city's end to try to get that done. I'm not sure
Well,
how we could
keep in mind
find that we didn't have a certificate of we never did.
Well, that paragraph says
construction.
Right, and that paragraph says that you were notified that those were the violations, not that that's what you were found in violation of. So I think that's a distinction that's necessary.
I mean, we got
So
approval.
I remember,
Build, and then at the end of the build, you get a certificate of occupancy.
I understand.
Yeah, and so how could we?
The only thing I remember, and I'm not testifying, is I remember you being here and me being here 3 or 4 times,
Yeah.
but I cannot recollect what it was about, unfortunately. I don't know. I don't know if Mr. Dewar does. Well, you could help if you wanted to.
If you go to page 2, it'll summarize some of,
Oh, I'm looking at page 2.
thank you, the city's case, which includes the fact that, as Mr. Limbowski has just said, there were maintenance issues which were addressed, but this property sat without construction activities for,
That's not sure. We have considered.
Wait, hold on. Let Mr. Dewar finish, and then you can retort that if you so
reason why the case came to the special magistrate back in November is that the property sat without construction activities because of the difficulties the Limbowskis were having. And you can see that from paragraph 8, that he testified that some progress has been made, but additional time is needed to complete the work. They were having problems with the general contractor. I then explained that there were some matters that were corrected, and Ms. Anderson, who was the city building division manager, testified that she visited the property, had conversations with the contractor, and she then subsequently issued a letter detailing the items that were not compliant, and those items needed immediate attention. And part of the discussion we further had at the hearing was that the Limbowskis needed to have a CO to bring the property into full compliance. That CO was issued in October of 2023.
This is where I have a problem. And this is where I also need to figure out if I even have the ability or the jurisdiction if it's not, this is not necessarily, well, let me step back. The order says, on page 2, the respondents are directed to take all action needed to have licensed contractors complete the work in accordance with permits issued by the city and in accordance with the letter from Ms. Anderson dated October 10th. Cool. Then it says the respondents are directed to bring the property in full compliance with property maintenance requirements by November 14th, 2022, and the respondents are required to allow city code enforcement officers and building officials to inspect the property on November 15th or such other date agreed upon by the city. There's nothing in here that says that a certificate of occupancy is required. There's nothing in here. It says that the full compliance has to be with the property maintenance requirements. I don't know what those property maintenance requirements are, other than a letter that I do not have from Ms. Anderson, so I don't know if it was complied with. That being said, whether or not this order was complied with is usually at the determination of the city.
Correct.
But now I have a fine reduction request in front of me.
May I, Madam Special Manager?
Yeah, you may.
So 9865 and 9866 are the maintenance requirements, right? And those fall under the purview of the Code Enforcement Office.
And I'm not disagreeing with you.
Yes, ma'am.
Building permits do not fall underneath. Is that in Chapter 98? Because I don't have those code sections in
I
front
was
of me.
going to continue by saying that 3.7 falls under the purview of the building official, and is why you have the outline of code enforcement as well as the building official in this summary. Part of the reason why those two agencies were involved is that code enforcement dealt with the maintenance and the building official dealt with the certificate of occupancy, and is why we were both collaborating on this project to bring it into full compliance. Full compliance meaning that the construction had to be completed until a CO was issued, and the maintenance had to be maintained.
That's not what this order says. This order says in full compliance with property maintenance requirements.
I understand that, ma'am. I don't disagree with you. I'm just letting you know
know.
what, the reason why the two agencies were involved in this property.
Okay, and this falls under, let me see what my requirements are. Under the lien reduction.
So, Madam Magistrate, can we,
Can we get, just 1 second, I want to read what my duties and responsibilities are with regard to the lien reduction request. Have been corrected. Well, that's fun. Okay, yes, Mr. McConnell.
so 98-65, I understand what Mr. Dewar said about property maintenance. But specifically, if I may read it into the record.
Yes, please do.
1C. Okay, so I'm going to read, the following conditions are hereby deemed to be unsightly conditions and are prohibited. 98-65 is titled Unsightly Conditions. Following conditions are prohibited on any real property in the city. So paragraph 1, structures that are, little c, left in a state of partial construction beyond the valid time frame of the permit. I believe that's why all of this was connected. But the issue that I have legally is the testimony that's in the order and the finding of fact from Ms. Anderson, paragraph 10, which clearly states that this was a 5-year process, right, for permitting, but that the city was extending the permit in an effort to work with the property owners.
Which then would not implicate subsection
So
1C.
I'm trying to piece this together as you are.
Yep.
But I think that's where it tied to the code enforcement issue, is because it was a partially constructed building for so long that was past the time frame of the permit. So then when we're in front of the hearing, we used Mr. Thanis with, I think, the consent of the property owner as well to kind of lay out a game plan of how to get this over the hump.
My issue is the order from Mr. Thanis is dated November 8th, 2022, and his compliance date is November 14th, 2022. And I have had representations from both sides today saying that the property needed to be completed and a CO needed to be issued within a period of time from November 8th to November 14th. I can't imagine Mr. Thanis thought that that would be possible to comply with the code based on the status, based on what I'm reading and what the status of the property was.
No. And I can't speak for the prior orders. I wish we had them, but I can pretty confident that those prior orders were the same thing, although you guys would need to find those. This was kind of like the point.
Yeah, and I can understand that. And also, my powers and duties within your code state that I can grant the violation, or the lien reduction, as long as all city code violations have been corrected under necessary permits issued, which we said that there was. And I also can consider the application to reduce the fines, to reduce it unless I find that no violation of a city ordinance existed on the subject real property. So apparently I can go back and figure out if there was ever a violation, which I am not going to do today, just so you know. But it does give me kind of latitude, and I do have pause. It is a significant amount of fines, and it is based on the CO being the compliance date, which understanding the city has some discretion, I cannot see, and having not been there, cannot see that Mr. Thanis, and knowing Mr. Thanis, would have given a less than 10-day period for a CO to be secured if the property took then 11 months to complete.
From that point. So
From that point.
Probably 6 years total.
Well, 11 months from November 8th. So
think
does anyone recall how far along the property was to be completed? Yes, please, yeah.
Part of what Mr. Dewar is talking about that Julie Anderson gave to us was a list, and we were compliant on that date with all of the code infractions and the construction elements. right? Mr. Thanis wanted us to have, the property was framed. It did not have sheetrock. It did not have plumbing. What he wanted was a construction schedule and the documentation proving that we had a licensed general contractor on premise. We gave all that, and we had all that. We were
Prior to the hearing or after this order?
prior to the hearing.
Okay, so then that begs, then,
That's what the hearing was.
right, then that begs, what is this order for? Because again, and I do find it interesting, this is an order affirming the finding of the code violations, directing compliance, and imposing fines, which is odd because you're directing compliance. I don't have another order after this saying whether or not it ever came into compliance on November 15th.
Correct. And the only thing I can go to the property owner's point is paragraph 10 and 11, which clearly state that Ms. Anderson testified that while 4 of the items were addressed in her letter, there were some remaining items that have not been addressed, and the property remained non-compliant.
Which is fine, but again, doesn't mean that this issuance of the COs, I don't have that information if the issuance of the CO was one of those conditions on that letter.
I don't. I think the problem is it was the cart before the, it was like,
Yeah.
the only way to come into compliance and get this stuff permitted is eventually to work towards a CO, but the only way to get the CO is to get this
Is
stuff.
to hit this punch list that we,
Yeah.
because it does say they need to get a licensed contractor, work in accordance with the permits, and the letter from Ms. Anderson dated October 10th. So it's, my reading of it, having no other information, is this has been going on a long time. We have a resolution. Here's a letter with tasks that you need to complete. Here's those tasks need to be completed by November 14th. You need to get the building official out there by November 15th to make sure these tasks were all completed, and code enforcement to make sure these tasks were all completed. And I cannot imagine with any reasonable person, based on the testimony here today, that that meant getting a CO. I just don't see that possible based on the status of the property at that time. So what I can do is see, because it would have been a public record and it's only from 2022, Ms. Anderson's letter should be available somewhere. So if it's something we can put our fingers on quickly, we can take a brief break and you can go grab it, or if it's something that takes time, we can continue this. I guess we're going to take a brief recess to go grab that letter.
Can you grab the orders too?
We will reconvene at no later than 12:15. It may be earlier, but no later than 12:15. We will, yeah, we'll go off the record now. The record. Mr. Dewar, I believe you have
Can we
some.
go to the overhead, please? And this is the letter from Julie.
Go to this.
Can we zoom in a little bit, just
Yeah,
a tad?
I mean, I'm
just a
squinting.
tad bit. We're kind of straining. Thank you. There you go. Thank you.
Okay. I
And
just-
so
Mhm.
these, and we have additional items here. The meeting minutes. If you
Item
go to
3B.
right,
This is from what meeting, Mr. Dewar? At the very top,
September.
September 12th.
2022.
Okay. Mr. Dewar.
Starting B.
which is- Okay, but there
And
was
it
another.
continues.
Okay, hold on.
1 second, go back.
This is the meeting before this order was issued then?
Correct.
Because this is on the November
Just to
meeting.
give a little bit of context to that order.
I don't,
We have this in order if you would like to see.
no, I'd like to see the meeting minutes,
All right.
and I need to be able to read them, so. Okay, next page, please.
Page 2.
Okay, so it looks like Mr. McConnell asked to reserve the rights to argue and fine for the CO being issued by December, but I don't have any, do we have the meeting minutes from November? By chance to see where that went? Because there's nothing in this order from the next meeting that talks about issuance of the CO or even mentions a due date by December, which would make more sense if we're talking about the issuance of a CO than giving a less than 10-day window. And Mr. McConnell, do you have any independent recollection of that?
Would we be able?
I mean, I remember
Jenny,
saying this because
Jenny has it.
she has the meeting minutes. I believe the next hearing, because you can tell I continued the September one to November, so the next hearing would have been the November one.
Right, which is
Why he's imposing a fine.
correct, but not with relation to the CO. And in that hearing, you said that you reserve the right to argue that for a December issuance, and there's nothing in here with regard to a December deadline for an issuance of a CO. All it says is to comply with the property maintenance, and then the schedule, which Ms. Anderson's listed punch list don't mention acquiring
Yep.
a CO. One of these days. So then the next question becomes, if I don't have the meeting minutes and I have nothing on the CO, the way the plain reading of the order and Ms. Anderson's punch list don't say anything about a CO. And in fact, the meeting minutes from the September hearing state that there would be further argument in the future with regard to the CO. So to me, the CO is not the compliance. Unless I have further information, the CO is not the compliance trigger. It would have been everything on that punch list, which then there would need to be proof to the city that everything on that punch list had occurred. That's going to be on the respondent to provide when you delivered that information to the city. And that's going to be when we're going to have to figure out when that fine deadline ends so that we can figure out any type of reduction request based on the actual amount of the fines. Excuse me. So again, I have two options at this point, and I feel like I'm leaning towards one, unless the meeting minutes identify what happened with the CO. And I'll let Mr. Dewar speak to that.
Those minutes do not reflect mention of the CO.
At all, okay. So based on that information, I'm happy to consider the fine reduction request. However, I want to make sure I consider the fine reduction request based on the actual total amount of the fines and if any fines should have been assessed at all. That being said, it is the respondent's responsibility to demonstrate that the code has been complied with, meaning that the order that came down from Mr. Thanis on November 8th specified that the property had to be in full compliance with the property maintenance requirement by November 14th, and that punch list by Ms. Anderson needed to be completed by November 15th, and an inspection needed to, or November 14th, and an inspection needed to occur on November 15th or some other time agreed to by the city, which means proof needs to be demonstrated that those things happened and by which date they happened on. If they happened by November 14th and you can provide me that information that it happened before November 14th, then there would be no fines assessed with this. There would be no fines imposed per Mr. Thanis's order. However, if they happened on November 20th, November 26th, a $250 a day fine would occur, but it would only do so until the property comes into compliance, which may substantially reduce the amount of the fines that are assessed. It may not, but that's going to lie on you to provide that information to me. So what I'm going to do is allow for a 30-day extension on this, and we will reconvene on October 14th's hearing. And that should give you sufficient amount of time to find that information, the city to find whatever you have as well, to demonstrate whether or not, or what date the order was complied with. So it's not going to be the issuance of the CO. That's not mentioned here. We have meeting minutes that say that was going to be a reserved argument for a future date. That apparently did not happen. So the compliance pursuant to this order is that it was the maintenance requirements were done, and that punch list from Ms. Anderson, I think it's going to be hard to find the maintenance requirements, but the punch list by Ms. Anderson, those items should have been completed and submitted to the city. It's your responsibility to find out when they were submitted, and that would be the compliance date. You may.
In order to move forward with any construction, because the delays would happen when we were unable to construct because the city wouldn't allow us to build because we weren't in violation, we needed to comply with that punch list immediately. And it was all in the hands of a general contractor, and knowing that this is 2 full years ago, and some of these companies don't even exist anymore, it's going to be difficult for me. But
sure, and I
80,000 is a big number. 87 is a big number, but even $1,000 is a lot for me. I'm going to be paying that.
Can be a lot. So, and that's what I'm saying.
I just want it to be fair.
And I'm trying to make it as fair as possible, considering that based on the information I have to date, all I have in front of me is that's an $87,000 fine. The fact that I have the order and able to read into that, and based on your testimony, I'm giving you the opportunity to provide counter evidence to what we have.
Sure.
Otherwise, I'm gonna just have to go with the CO date because I have no other date of compliance.
Okay.
So I need to find another date of compliance, and it is your responsibility as the respondent to comply with the order. So it's your responsibility to find that for me. So I'm giving you extra time to do that.
But I guess what I'm asking is, can I have maybe the punch list from Julie again?
Absolutely.
Whatever evidence I need to come show, because in order for us to move forward, we did all this, and we did all this for the last magistrate hearing. So it's there, but it's going to
I agree. I just need to know the date. So yes, if you could, and I'm sure the city will provide you with a copy of the punch list, and then we will reconvene on October 14th, and you will bring me whatever you have.
Just even one inspection would prove that we were in compliant enough to move forward. And
No, the way that the order reads is you need to comply with everything on that list. Okay. And I think a majority of it, or at least several items there were several items that were not, according to this order.
I could do that.
So if you take that letter, we'll come back on October 14th, and you can provide evidence to me about when those things were completed.
Will they let me know which of the 4 items or however many items Julie already checked off so that I know which ones I need to provide?
You can get with the city after the hearing and certainly figure that one out.
We were very close. We thought it was all of them, and then Julie found discrepancies with some of them. I would like to know which ones those are so that I could provide proof, because the other ones have already been.
Well, here's the deal. The other ones would have been before that November 14th date anyways. So work with the city to try and figure out which ones were outstanding. If not, then the responsibility still lies to you to prove that all of them were.
Okay.
And so either way, you have until October 14th to provide me with evidence of when this order was complied with.
Okay.
And then if you can do so, depending upon what that date is, that'll figure out when you came into compliance, that'll figure out the fine amount, and then I can go ahead and move forward from there to figure out if a reduction is necessary or how we move forward. So I will get an order to that effect out. That way there's a record of it. And make sure I have your contact information so that I can send that to you, and then we will reconvene on October 14th, unless y'all work it out some other way.
I appreciate it. Thank you very much.
Thank you. Our next meeting is scheduled for October 14th. And understanding it's Columbus/Indigenous Peoples' Day, the city will be open unless and until I find out differently. We will be here at 10 a.m. If there's nothing else, we are adjourned.
Thank you.
Okay.
Adjourned.
Y'all like to keep things interesting.
That was, see ya.